Hello everyone, welcome to SCO Explains. Today we'll be briefly breaking down the Supreme Court's judgment in the plea for marriage equality for queer persons.
On 17th October 2023, the Supreme Court rejected the plea for a queer person's right to marry in India. The five-judge bench unanimously agreed that there is no fundamental right to marry and that marriages between queer persons cannot be read into the Special Marriage Act of 1954. All five judges also agreed that transgender persons in heterosexual relationships have the right to marry under existing legal framework in the country. Further, in a 3-2 majority, the bench held that same-sex couples did not have the right to form civil unions, nor could they adopt.
4 opinions were written in this judgment by Chief Justice D.Y. Chandrachud, Justices S.K. Kaul, S.R. Bhatt, who wrote for himself and on behalf of Justice Hema Kohli, and Justice P.S. Narasimha. One thing that stood out in this case is that the Chief Justice was in the minority. This is not typically the case. Research suggests that the Chief Justice has been in a minority in a constitution bench only about 13 times in the past. And specifically in the past decade, the Chief Justice has been in the minority in a constitution bench just 3 times. That is in the Triple Talaq case, Reservations for Economically Weaker Sections case, and the present case.
So let's quickly dive into the highlights from the judgment. We'll begin with whether there is a fundamental right to marry. All 5 judges agreed that there was no fundamental right to marry. CJI Chandrachud held that though the Constitution does not expressly recognize the right, the state is obligated to create an institution where queer persons can enjoy the benefits of marriage. He said that queer couples have the right to union and that a separate institution like marriage could be recognized as a civil union. We'll get to what the other judges said on this in just a little bit.
Justice S.R. Bhatt agreed with the CJI. He held that marriage has existed before the formation of the state, which means that the source of it is not from law but from society itself. If there was in fact a fundamental right to marry, it would have to be brought into the levels of other rights in Part 3 of the Constitution, which deals with fundamental rights. But unlike other parts protected in Part 3, marriage, he said, is a personal preference, which confers social status, and it's not an enforceable right which the court can compel the state or governance institutions to provide. Justice Narasimha added that marriage is a fundamental freedom, not a right. So then, do queer persons have a right to enter into a civil union?
CJI Chandrachud was in the minority, holding that queer couples have the right to enter into civil union. He observed that the right to enter into a union includes the right to associate with a partner of one's choice. For a full enjoyment of such relationships, he said, it is necessary that the state accord recognition of such relationships. Justice S.K. Kaul agreed with the chief and stated that the right to form a civil union was a feature of Articles 19 and 21 of the Constitution.
Leading the majority opinion on this question, Justice Bhatt agreed only partially with the CJI. While he held that all queer persons have the right to relationship and choice of partner, cohabit and live together as an integral part of choice, he disagreed with the reasoning that the right to form a civil union in form of a new law must exist. Ordering a social institution would require a completely different legal framework with, he said, a new universe of rights and obligations. This would require a separate regime of registration for the civil union, laying down conditions of a valid union, setting eligibility, age restrictions, divorce, alimony, and a bouquet of other rights that are ancillary to marriage. The state is not obligated to recognize this bouquet of entitlements, Justice Bhatt noted.
The next big focus in the case was the Special Marriage Act of 1954. On the SMA, there were 2 key contentions. First, that the SMA was unconstitutional for violating the right to equality as it failed to recognize non-heteronormative marriages. Second, that the court must adopt a gender-neutral interpretation which includes non-heterosexual couples under the Act. So for instance, where the Act says man and woman in the provision, it should be read as spouse. So let's deal with each issue one by one. Is the Special Marriage Act of 1954 unconstitutional for excluding heterosexual couples? CJI Chandrachud held that declaring the provision unconstitutional would diminish the purpose of progressive legislation that the Act incorporates. The SMA, he reasoned, was enacted to bolster interfaith and intercaste relationships. Therefore, declaring it void would take India back to a pre-independence era where intercaste and interfaith marriages were impermissible. In contrast to the chief's opinion, Justice Call held that the SMA was violative of Article 14 as it discriminates against non-heterosexual couples. He saw that there was a clear distinction between non-heterosexual and heterosexual persons under the Act, and he held that there was no reasonable explanation for drawing that distinction. The intent of the SMA, he said, is to facilitate interfaith marriages that had no nexus to the exclusion of heterosexual couples from the purview of the Act.
Justice Bhatt wrote that the classifications made in law must be understood in the context of the objectives of that law. So, relying on precedents, he wrote that unless the excluded category in any classification belongs to the included class, it does not amount to exclusion. Justice Bhatt noted that the sole intention of the SMA was to facilitate marriage between persons professing different faiths. At the time that the law was made, consensual sexual relationships between persons of the same sex remained prohibited. Moreover, it was not the focus of the law. Therefore, he reasoned that as long as an objective of a law is clearly discernible, it cannot be attacked merely because it does not make a better classification. Moving to the second question, can the right to marry be read into the provisions of the Special Marriage Act 1954?
All five judges agreed on this question and held that marriages between queer persons cannot be read into the Special Marriage Act. Chief Justice Chandrachud held that adding, deleting, or substituting words in Section 4 of the SMA would lead to substituting words in other provisions of the Act and several other legislations such as the Hindu Succession Act, the Indian Succession Act, and several others. This would in effect be entering the realm of the legislature. He reasoned that this would violate the doctrine of the separation of powers. Though Justice Call held that the SMA violates Article 14, he agreed with the Chief that there would be multifarious interpretative difficulties when it comes to including non-heterosexual persons under the SMA. He accepted the union's arguments that tinkering with the scope of marriage under the SMA can have cascading effects across disparate laws.
Justice Bhatt wrote that Parliament intended only one kind of couples, that is, heterosexual couples belonging to a different faiths, to be given facility of a civil marriage under the SMA. The law cannot be interpreted in a way that is conceptually different from what Parliament must have intended, he said. Further, Justice Bhatt warned that a gender-neutral interpretation of the SMA would complicate an already exhausting path to justice for women and leave room for the perpetrator to victimize them. A gender-neutral reading of the SMA would also impact gender-specific aspects of the statute. For instance, separate legal age of marriage for men and women, remedies for divorce and maintenance would pose serious challenges under a gender-neutral construction.
The focus then shifted to adoption. On this, the bench split 3-2 with the majority holding that queer persons cannot adopt under existing legal framework. The petitioners had challenged Regulation 5.3 of the 2020 Central Adoption Resource Authority guidelines, which restrict adoption to single individuals and married couples who are in stable marital relationships for 2 years. Further, Section 57.2 of the Juvenile Justice Act mandates that both spouses had to consent for adoption. Chief Justice Chandrachud held that the regulation violates Articles 14 and 15 of the Constitution as it discriminates against unmarried couples. He highlighted that the regulation treats marriage as a yardstick to classify stable couples who are considered to be fit to ensure the best interest of the child. The Chief stated that the union had placed no data to support their claim that only married relationships could provide stability.
Justice Bhatt led the majority on this point and held that the Juvenile Justice Act makes it clear that adoption only concerns joint adoption by married couples. Reading both married and unmarried couples into the provision is not based on any known principle of interpretation, he said. The law is designed this way, keeping in mind the best interest of the child, and to protect it from instances where the marriage is broken down. Marriage becomes a key prerequisite to attract protection from laws on divorce, custody, guardianship, maintenance, succession, among many others. This framework ensures that if one parent abandons the relationship, the other can maintain themselves and the child. A remedy that a couple with no legal recognition is deprived of. Justice Bhatt clarified that though a married couple is not a morally superior choice, the adoption framework takes into account the protections and entitlements which flow from the institution of marriage. The guiding principle of the Juvenile Justice Act is the best interest of the child, not to enable adoption for all, he said. However, Justice Bhatt recognized that in the absence of a legal recognition of queer couples, that they have no option but to adopt individually. This would mean that neither the parents nor the child can enjoy any legal protections. He said that the state needs to ensure that maximum welfare and benefits reach the largest number of children in need of safe and secure homes, with promise for their fullest development.
The next question that the bench dealt with concerned the rights of transgender persons in heterosexual relationships to marry. All 5 judges agreed on this point. Chief Justice Chandrachud held that a transgender person in a heterosexual relationship is entitled to marry after a harmonious interpretation of existing marriage laws and the Transgender Persons Act of 2019. He reasoned that marriage laws in India permit marriages arising out of heterosexual relationships. The existing laws, such as the SMA or other personal laws, describe marital relationship between a man and a woman, a husband and a wife, a bride and a bridegroom. If this is restricted, it would violate the Transgender Persons Act, which prohibits discrimination of transgender persons. Further, he stated that a person is a transgender person by virtue of their gender identity and not their sexual orientation.
In a little over 150 words, Justice Bhatt concurred with the CJI, declaring the Madras High Court's judgment in Arun Kumar versus Inspector General of Registration, a 2019 judgment, was correct analysis. In Arun Kumar, the Madras High Court had held that a marriage solemnized between a male and a trans woman, both professing Hindu religion, was a valid marriage. With this, we wrap up the key points in the marriage equality judgment. Visit scobserver.in for our judgment summary and a matrix where we break down each judge's opinion. You can also access reports on all days of the hearings in one place. Thank you for watching.